If you're not familiar with this channel, we multi-stream, broadcast all over the place, including Periscope, Facebook, and now YouTube. And it looks like we're live across the board. Hello, everybody. Welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler, and I am a criminal defense attorney here in Scottsdale, Arizona. And over the course of many years in practice, my team and I, we've helped thousands and thousands of people facing criminal charges get their lives back on track. And over the course of that time in practice, we've seen a lot of problems with the criminal justice system. In particular, I'm talking about misconduct from police, malfeasance from prosecutors. We see problems with judges, problems with politicians, problems with court clerks and prison guards. Anybody and everybody involved in the criminal justice system, there's been some sort of problem, some sort of position where there's been issues. And so what we want to do on this show called Watching the Watchers is watch them, call them out, hold them accountable, shine the beautiful sunlight of disinfectant right down upon them so that we can wean out a lot of this misconduct that we see on a daily basis. And part of what we do is we are monitoring these politicians. We're holding them accountable. We're analyzing and seeing how they are conducting the operations that are going to trickle down and impact our lives. And one of those operations is, of course, the confirmation hearings, which are well underway at this point in time, of Amy Coney Barrett, who Donald Trump nominated to be on the Supreme Court. And so yesterday we did a deep dive analysis on what happened during day one of those confirmation hearings. Today, what we want to do is go through day two. So yesterday, if you recall, was a lot of uninteresting information. We saw a lot of opening statements, a lot of questions were not even asked, but there were a lot of sort of political statements that were taking place by all of the different senators who are on the Senate Judiciary Committee. And so today we got into a little bit more of the interesting stuff, some of the more substantive, meaty material, because this was the day that Amy Coney Barrett was going to be fielding questions from all of these different senators on the Senate Judiciary Committee. And so today we've got some clips, we've got some different things that I want to cover, and so let's just dive right into it. Now, I don't have clips from all of them. If you recall, the framework for how today was supposed to work is each different senator was going to have 30 minutes to go through their points, which is a long time. And we're going to see that some of those senators used it all, some of them didn't, and some of them asked questions and some of them didn't. Some of them just used that 30 minutes, that time, to just kind of get up there and pontificate about whatever they wanted to talk about, which is pretty standard for these types of things. Now, I first started watching these. I think the first one that I really watched closely was back when I was just thinking about law school. I was watching the confirmation hearings for Justice Roberts. So John Roberts was going through the confirmation hearings. That was really my first. I was younger. I think that was about 2008, 2009, I think it was. And, I've seen several of them since that time. And some have been a disaster and some have been, pretty okay. And the one that we're talking about that was a disaster was the one with Justice Kavanaugh, if you recall that, right? That entire confirmation spectacle turned into this referendum on this rape allegation that took place 25, 30 years ago with the woman, I can't recall her name, but, this was sort of a different tone. Amy Coney Barrett's confirmation hearing has been, in my opinion, a little bit of a lower volume, which is good. But still, what we're going to see as we go through this analysis is this is the moment for these senators to shine, and they are going to milk every minute of their time. And what I mean by that is, a lot of the time they don't have a national stage. They're typically, state senators. They're well known throughout their state, but they don't have a national platform. And so they know now that the entire country is watching this. Everybody, from every single state is interested in what's going on. And so many of them use this as sort of a jumping off tool to launch other ambitions that they have. We saw this during the Kavanaugh hearings. We saw Senator Booker. We saw Kamala Harris going really hard against Judge Kavanaugh. And shortly thereafter, I think they were in the middle of their actual Democratic primary campaign. So we're sort of in a little bit of a different time now because there is no ongoing election, at least for many of these senators. But some of them are in the middle of it. So Lindsey Graham, for example, is in a highly contested election. So this is his platform to say something about that. and to get the facts out that he wants you to hear. We're gonna hear that he comments about a lot of issues that are specific to his personal campaign and aren't really relevant to the rest of the country. So they're making these political statements to support their campaign, but we don't really care much about it. But because they have a national platform, they are going to dive into it. So first and foremost, the day started off with the chairman of the Senate Judiciary Committee, Lindsey Graham. You can see him. This is a screenshot. And, Lindsey Graham, if you're not familiar with him, he does this, aw shucks, I'm just a dumb Southerner type of shtick, which kind of gets old in my opinion. He does this all the time where he's like, well, I'm just, happy-go-lucky. I'm just an idiot. And I need you to explain to me how this stuff works. And so that was kind of his temperament throughout this conversation. Now, Lindsey Graham's a pretty bright guy. There's no question about it. He knows this stuff. He knows about substantive due process. He knows what legal precedent is. He knows all of that stuff. But he's having this little conversation with Amy Coney Barrett about all of this stuff, sort of teeing her up to hit these things out of the park. So that's what he does. Now, what I'm going to do on this show is I'm not going to play clips of everything because it was 8 hours of, quite frankly, a lot of mind-numbing content. But what we are going to do is I'll just give you a quick summary. So when we're talking about Lindsey Graham, he actually, said, I can't explain substantive due process. He asked Amy Coney Barrett to do that. He did ask her to define originalism, which I thought was a very compelling part, and it was a good way to open up the confirmation hearing. So this is sort of the foundational principle on which Amy Coney Barrett relies in order to execute her duties. And her judicial philosophy is all centered in this concept called originalism. And since Chairman Graham had the opportunity to open the hearings, and because he's a Republican, he was able to sort of lay this foundation at the very beginning of the confirmation hearing today. And I think that served them well. So we have a clip because Amy Coney Barrett actually, she responds. I think she's got a perfect answer for what originalism is. But this is the clip from the confirmation hearings today.
You said you're an originalist. Is that true? What does that mean in English? Pass the button. I mean, we all love Senator Lee, but in English.
In English.
In English.
Okay, so in English, that means that I interpret the Constitution as a law, that I interpret its text as text, and I understand it to have the meaning that it had at the time people ratified it.
Okay.
So that meaning doesn't change over time, and it's not up to me to update it or infuse my own policy views into it.
So in other words, you're bound by the people who wrote it at the time they wrote it. That keeps you from substituting your judgment for theirs. Is that correct?
Yeah.
All right.
Yeah, and so this is something that we hear a lot about as the hearing goes on, this concept of originalism, and it's so important because this is how judges think. This is the key question. If you are presented with a case in front of you, and you have a set of laws, you have some statutes, you have a set of facts, you have a plaintiff, you have a defendant, you have a prosecutor or a criminal defendant. How are you going to analyze the issues in front of you? It's not about what are you going to analyze or what the conclusion is going to be or how you're going to rule on the case. It's about how are you actually going to start unpacking all of that. So, some people do it differently. And what we're talking about specifically is how Amy Coney Barrett is going to approach it. Now, she talks about being an originalist, and you just heard her there say specifically that what we do is we take the text of the language at issue, so the text of the statute, the text of the Constitution, and we analyze that language. That is it. That's it. We look at the language. Now, there are other things that could be in the realm of potential analysis. And so many people will say, well, yeah, I mean, of course, right? Isn't that it? Isn't that the only thing? Isn't that the only way to analyze law? And the answer is no, there are other ways of doing that. And so one of the things that they talk a lot about throughout this hearing is diving into, and we'll get into this, I think I have a clip of it, they'll get into what's called legislative history. So let's say, for example, let's sort of flesh out these two things because it's going to be a theme that runs through the remainder of these hearings, is if you're an originalist and you're looking at the original text, that's all you need. You look at the text, you say the facts are applied, the text applies to these facts in this way, and that's it. But a different way, another alternative to doing interpretation or analysis is to look at a bunch of other stuff outside of the text. And this is what some judges do, is they'll look at the text, but then they'll also look around the text. So they'll look at the debates that took place in the committees. So if a issue, somebody introduces a bill, it goes through the Ways and Means committees in the House of Representatives. They have a bunch of different debates. They have different amendments. They have different co-sponsors. Different things happen. They submit different exhibits. They send it over to the Congressional Budget Office, who files a report. And you have all these different agencies and all these different lobbyists, and you have all of these different documents sort of being a part of that official record. And what those other judges who are not originalists are saying, they're saying, well, that's all relevant because all of that was important to the drafters of the final law. So they'll look at the law and they'll say, yeah, we don't really know how to analyze that. So what we should do is go back and look at all these other things. Well, what did the people who wrote it say? What did they talk about? What were their issues? What were their concerns? And then what they'll try to do is they'll take the written law as well as everything else, and then they'll craft a solution on that basis. So what Amy Coney Barrett is saying is, no, we don't do that. We just look at the law. All of that other stuff, the debates, the conversations, the different adjustments and all the stuff, that any of that is irrelevant because it's not part of the final law. We should only be operating based on what is in writing, what is in front of us. And so that is really what she is describing, and it's a good way to frame out the rest of the confirmation hearing because this is the foundation. All of these other issues, she's going to come back and say, sure, yeah, the Roe versus Wade, yeah, I would look at precedent. I would apply my originalism to the rules that the Supreme Court has established for following precedent or overturning precedent. And so she is continuously coming back to this concept, which is why I wanted to spend a little time on it. Lindsey Graham doesn't do much else other than sort of tee her up. He talks about Heller, which is the individual right to bear arms. He talks about what's called about Roe versus Wade. He brings that up at the very beginning of this entire confirmation hearing, which was, I think, a smart move. This was a good decision. When we're talking about doing trials, or we're in trial practice, or if you're in law school and you're learning how to do trials, one of the things that they teach you to do is what we call drawing the sting. And so this is a concept where it's going to sting when these things come out, when these facts come out, or when this issue is raised. If you have a bad fact, if you have a DUI case and your defendant did something that was not so good, or said something that was not so favorable to your case, and you know that the other side is going to bring it up. You know it's coming. So you bring it up first, and you just sort of draw the sting, you deflate it. You almost take the power out of this issue by just talking about it. And so Lindsey Graham sort of does that. He brings it up right at the beginning saying, yeah, Roe versus Wade, that's going to be a big issue, so let's talk about it. And he does, right? And they talk about it a little bit. Nothing super substantive, nothing really that's going to be satisfying to anybody, but they do talk about it. We learn in this case that Amy Coney Barrett owns a gun, and that she's obviously highly Catholic. She talks briefly about the Obergefell case and substantive due process, but not much else there. So it's something that was a nice introduction, but then it moves over onto Senator Dianne Feinstein. So she is next up, and as we are familiar with her, she sort of is the minority chairperson of the Senate Judiciary Committee, and she just goes right into the typical talking points that I think we would all expect. The first one that she mentions is abortion. She talks about the Affordable Care Act. She is really, as you go through it, she's really frustrated that she can't get a straight answer out of Amy Coney Barrett on any of this stuff. And this is the first opportunity where Amy Coney Barrett starts to actually use the language from the other formally nominated left liberal judges. She uses their own words to explain why she's giving a non-answer. So she actually references Justice Kagan during her confirmation hearings, saying that she's not going to give a thumbs up or a thumbs down. So that's not Amy Coney Barrett's words. That's Justice Kagan's words. Justice Kagan during her confirmation hearing said, I can't give thumb up or thumb down to precedent. That's not appropriate. It's violative of the judicial canons of conduct, and so they're not going to do it. Amy Coney Barrett also talks specifically about the Ginsburg rule, where Ginsburg is saying that she's also not going to comment on these things. And so she's using these liberal left judges to make her point when she's being questioned by the Democratic senators, which is very brilliant. It's very well done. We've seen this in the past. It's not a new tactic, but it is good to sort of just deflate that argument, because what is happening in this situation is that Feinstein is just, question, and they don't accept her answer. So she'll say, I can't answer that because it's a current case in controversy. It's going to be before the court. It would be a conflict if I gave you a hard answer on that right now. And then they just say, okay, we understand, and then they ask it again in a different way. And so when she is able to use their own judges sort of against them, it is powerful. She does say in her conversation with Dianne Feinstein that she's going to follow the rules of stare decisis, and that will be that. Now, there was a moment here where she was talking about sort of this concept of Roe versus Wade, and this stood out a little bit, where she said that she's going to follow. Senator Feinstein was hitting her again and again and again on Roe, and Amy Coney Barrett specifically said that she is going to follow the rules of stare decisis. And so that means that she's going to stick to prior precedent. In my mind, the issue with Roe versus Wade is that it sticks out a little bit. It really is not sort of in line with other Supreme Court precedent, because we saw it get sort of scaled back down, or I would say more closely tied to the constitutional framework of our country in the following case, Casey versus Planned Parenthood. So we had Roe versus Wade, which was modified and actually tied better into the Constitution under the undue burden rule under Casey. But then what we're seeing is that, everybody's really sticking into Roe versus Wade. So when Amy Coney Barrett is going through her analysis and says, I'm going to stick to precedent, I listen to that almost as a wink, like, yeah, I'm going to follow precedent. And when Roe versus Wade comes in front of me, I'm going to follow it hard. That's kind of how I heard that. And Roe versus Wade, I think, is that nail that's sticking out. All the other nails have been hammered into place, and Roe versus Wade is that one. Just as a matter of the mechanism under which it was decided, I think, makes it less secure precedent. And so when she's saying, I'm going to follow precedent, I did take that in the context of Roe versus Wade as saying, yeah, if it's in front of me, it's bad law, and we're going to follow the good precedent, and that one is not going to make the cut. Now, what does that do for abortion rights? Probably not a lot, right? If this is thrown back over to the legislative branches, if the court gets out of the business of passing legislation from the court, from the bench, this all goes back to the legislative branch, which is where it should be, which is where it belongs. Are the state governments really going to, outright ban abortion? I don't think so. I think it's a political question, but we'll see. She goes through, and this was the first time I thought this was interesting. Another thing that you learn in law school is to use these delay words, these buffer words, to sort of give yourself time to answer questions. And this was the first time that we saw Amy Coney Barrett do it. And we see this a lot with people in these positions during confirmation hearings. But Amy Coney Barrett did a little bit differently, enough that I noted it, where she says, let's see. So before she starts answering a question, this is a good technique for you to use anywhere, not just in courts or during confirmation hearings, but if you're in a conversation, if you're having an interview with somebody and they ask you a question, practice putting in some of those buffer words before you respond. And so some people will say, well, so somebody asks you a question, you say, well, and that gives you that split second to formulate your thought. I say, well, a lot, and I say, of course, a lot. And, it's kind of a bad habit, but it's also a good thing to do when you are preparing to say something important. And so what she says here is, let's see. So you'll see that a lot. A lot of the senators are asking her questions, and she says, let's see. Then she responds. Remember when Mark Zuckerberg was in front of the Senate? He did the same thing. He was, I think, highly coached and trained on what to say, but he used the word senator. Remember, he would say that at the beginning of every single sentence. It got annoying to listen to him speak. But he said, senator. They would ask him a question. He would say, senator. The answer to your question is, and then he would respond. So it's just a way to slow down your talk, to slow down your reaction. A lot of the times people will be quick to react instead of respond. And if you put those buffer words in, it can really help you, because as I was listening to Amy Coney Barrett, I was thinking, oh man, she could just immediately respond and just nuke that statement because it's an inaccurate statement, or it's a fallacy, it's a logical fallacy, and she could just kind of run rings around these people, but she didn't. She didn't react. She responded, and I think in large part that's due to her training and because she is thinking about it, and she's actually, she's not just good at this stuff. She's actually following good technique, which is to put that buffer word in. They talk a little bit more about the Ginsburg rule. They talk about racism and the separate but equal stuff, but not a lot real substantive out of Feinstein. So you can see here, we didn't clip much there. We move on. We get over to Senator Chuck Grassley, and he's got some interesting things to say as well. He says that he kind of does his introduction as all of these senators do, and he says that judges are different than legislators because you can vote out the legislators, you can't vote out the judges. He also, again, talks about legislative history, this idea that what's happening in these private conversations off the books should not be what judges look at when they are issuing their rulings. They should look at the law that's in front of him. But then he goes through this and he brings up the First Step Act. And we have a little bit of a clip about this and Amy Coney Barrett talking about this legislative history stuff. What's happening during the debates, what's happening in the negotiations and all of that stuff. Well, Chuck Grassley was a senator who was very instrumental in pushing forward the First Step Act. Well, the First Step Act came under fire because there was some contention about how to interpret the statute, because there's a language in that statute, and Amy Coney Barrett goes into this during her confirmation hearings, but she's talking about the First Step Act gave people certain privileges at a certain point in time. In this case, it was after a criminal defendant got sentenced. So when you go through, you've been charged with a crime, you're going to go through the court process, you're going to have all your pretrial conferences, you're going to litigate the case for a certain period of time. And unless you are, get your charge dismissed, or unless you go to trial and you're acquitted of those charges and your case is thrown out, then you are going to either plead guilty or you're going to be convicted of a crime. After you're found guilty or you agree that you're guilty, then you'll have a sentencing phase in your criminal case. And so what Amy Coney Barrett is talking about is, what are those privileges? The First Step Act said that the line in the sand is sentencing. So if you were sentenced after a certain date, then you get these privileges. But if you were sentenced before a certain date, you don't get those privileges anymore. And the issue was, well, what is that line? Is it really the sentencing date? And because the statute was written poorly, it's hard to decide. So Amy Coney Barrett's position is, we just look at the statute. We say the statute said sentencing. Cool. If they had a sentencing hearing and that was done and over, then that's the line. But what the majority in the opinion said was, no, that's not the case. What they want to do is look through all of the other stuff, all of the other comments and debate transcripts and all of these other things to say, okay, we know that this is what the law says, but that's not what they meant. So what we're going to do is we're going to actually we're going to tweak this law a little bit to make it more in alignment with what they meant. And that is where we get into two different philosophies. One's the originalist, says, no, we got to just look at the statute. The other is we want to interpret what happened underneath. So here we have, the reason why this is so interesting is because Chuck Grassley is a part of the author, right? He's a Republican. He's part of the author of the First Step Act. He's obviously very proud of it. And so he's in this little conversation with Amy where he's saying, what's your opinion on this legislative history thing? Because we kind of needed that for the First Step Act. And she could have easily come out and just said, you should write better acts. You should write better opinions. You should write better statutes, write better law, and we won't have to do this thing. And so what you're going to see here in this next clip is Chuck Grassley asks her a question about legislative history, and she answers it pretty clearly. And then if you continue to watch the clip, he says, well, I'm confused. How did you find it that way? And she's very, very diplomatic about her, her response to it. But she could have just said, Congress should write better laws, which they should. All right, let's get this clip played.
Well, I think you probably know, Judge, how important it is. I want to know how important legislative history is to you. When is it appropriate to look to legislative history to interpret the statute? And are there some circumstances when more appropriate than other? And I'd like to also give your view on legislative history compared to what I heard from Scalia 35 years ago.
Sure. So I'm very comfortable talking about the use of
I
legislative
sped this
history
clip
because
up.
That's a matter of interpretive philosophy. What governs, of course, is the text of the statute. So, the legislative history can never supersede the text, and it should never substitute for the text of the statute. Justice Scalia, as was well known, railed against the use of legislative history, and I think it was because at the time that Justice Scalia went on to the D.C. Circuit, before he was on the Supreme Court, the use of legislative history had really kind of gotten out of control, and many courts, were saying things. Justice Scalia in his book quotes this line from a brief, the legislative history being unclear, we turn to that other reliable guide in statutory interpretation, the statute. And that has things backwards. And so I think Justice Scalia really tried to clean that up and say, listen, the priority is the text. And when the text answers the question, you don't go to legislative history. And there's some pragmatic reasons to be careful about doing so. Legislative history can be long. There's a famous quotation from Judge Leventhal that legislative history is like going to a cocktail party and picking out your friends. It can be easy to manipulate because there might be something in there for everyone. So as a general rule, I don't look to legislative history when I'm deciding cases. I wouldn't say that it would never be relevant. Even Justice Scalia himself said that there could be instances, for example, if you were trying to determine whether a term used in a statute, how it was used, if it had a technical meaning or how it was understood, that might be an appropriate time to consult legislative history. Or Justice Scalia himself consulted it when he was trying to determine whether there had been an error in the way the statute was drafted. He looked to legislative history to see whether what seemed unthinkable actually was unthinkable.
Now I'd like to go to a specific case.
Yeah, so he goes on and he goes actually to that specific case and he says, okay, well, all right, now that I know what you have to say about legislative history, when the next issue was in front of your court and you had to interpret my statute that I wrote, you said that you can't look to the legislative history. And he's kind of needling her to say, you should do that, which I totally disagree with. If the statute is written poorly, then that's not on the judges. The judge doesn't have the opportunity or the duty or the obligation to modify that. If it's a bad statute, the judge holds according to that statute, sends it back over to Congress. Congress needs to get their act together and fix the statute. But we don't want a situation where judges just say, yeah, I mean, I know what's written here in front of us, but I read the debates and that guy had a really great point. And so I'm going to actually kind of modify this thing a little bit because I want it to fit the facts that I want. It's if I just apply the law as it's written, it's going to be an unjust outcome. So I'm going to tweak the law and make some modifications so I get a more just outcome. And what Amy Coney Barrett here is saying is, sorry, no, you wrote the law. I'm going to apply the law as written. And if you don't like that, maybe you should write better laws. She didn't say that. Of course, I am expounding on that, but she could have easily said that, right? He was kind of needling her to say, look, why don't you look a little bit more towards this legislative history? And she's just, no, not going to do that. Now we go on and we have another from Senator Cornyn who says, hey, Amy, what are you looking at over there for your notes? And she holds up this piece of paper and it's nothing, right? So all of these senators, look over here at Cornyn. He's got 3-ring binders just stacked with notes. And this was something that was very common. I mean, all of them were just, packed with notes and, documents and documents and documents. And Amy Coney Barrett has, it looks like a piece, this looks like something you get, at your hotel to write the address down or something like that. And so she has nothing, right? She's sitting there. I have another picture of her somewhere of her just sitting there with nothing in front of her. She's got a coffee when she comes back from lunch on the afternoon, and she's just grinding through this thing. And I gotta be honest. I mean, she's very in command the entire time up until this point. She is just highly in control. She knows exactly what she's talking about. Highly polished, not flustered at all, not making any weird facial expressions, just kind of hanging there. Very impressive showing thus far. So then we go over to Leahy. So Leahy was appearing virtually, and this was where he got this is what he looked like, and so he was calling in for the hearing, and he not a whole lot that came out of his line of questioning. Again, he had 30 minutes. I don't think he used the full time. He says, his opening statement is basically the same thing we hear from the Democrats all day. Trump is to blame for politicizing this process. We hear a lot of that. A lot of the senators start this confirmation process or their time in front of the camera to lay out the fact that Trump is, awful and so on and so forth. Now, they bring up a lot of people. They talk a lot about different people. So they go into these facts, and Senator Leahy does a lot of that. He actually goes through and he says, listen, do you know how many people are going to lose their health care if ACA is thrown out? And Amy Coney Barrett says, no, I don't know. And he just goes on and on. Do you know about this stat? No. How many people have voted? Do you know? I don't know. Do you know how many people have joined on the amicus for the Supreme Court case, whatever the case is? I don't know. And so she's just going, he's going through and through and through, and he's just trying to sort of rattle her up on that. But he does talk a lot about the people, and we're going to see this a lot as we go through the remainder of the hearings. But the Democrats are doing a very good job of sort of taking a play out of Trump's playbook. So if you recall, Trump during his last State of the Unions actually was very effective in my mind at being persuasive by using stories from real people. This is how real people are being helped. This is how real people are being hurt. Very powerful. He brings them into the room. He shines the lights on them. He brings them up. He gave, Rush Limbaugh the Medal of Honor, the Presidential Medal of Freedom, there in sort of this unexpected announcement, and he does this. He brings veterans, he brings Gold Star families, and he does a good job of it. The Democrats are doing that here, and this is not something that we see from them frequently. But Leahy did bring this up, and we're going to see it throughout. We're going to see it from Durbin. We're going to see it from Hirono. They all are sort of using these people, these real people and these real images to show that these issues are going to hurt real people. At least that's their position on it. And so a good example of that is this next one from Senator Dick Durbin from Illinois. You can see here during the confirmation process, he brings up this family and he says, these people require cystic, they have cystic fibrosis. Basically, everybody's going to die if you get appointed and overturn ACA. And so, it's a nice looking family, Christmas time with the stockings hanging in front of the fireplace and the family dog, right? Very, very sympathetic. And basically the point is you're killing this family. And, we see a lot of that from both sides. It's using people as showpieces to make your political point, but that was not off limits here. We also hear from Dick Durbin. Now, Dick Durbin actually gets into it with her on a couple different things, and I think this next clip is about George Floyd. One of the most powerful things of the entire hearing today that I heard, I listened to the whole thing. It was actually just finishing up with Senator Crapo as this show was just getting started. So there was I didn't watch the entirety of it, but I caught enough. I got the gist of what we need to talk about. But Dick Durbin actually talks about George Floyd in this one. He asked Amy Coney Barrett, how did this impact you? What was your reaction to the George Floyd situation? And Amy Coney Barrett has an answer that I think really just diffused this entire question. Let's take a look.
So let's talk about that for a moment from a different issue perspective. Bear with me for a couple questions. Have you seen the George Floyd video?
I have.
What impact did it have on you?
Senator, as you might imagine, given that I have 2 black children, that was very, very personal for my family. Jesse was with the boys on a camping trip out in South Dakota, so I was there, and my 17-year-old daughter, Vivian, who's adopted from Haiti, all of this was erupting. It was very difficult for her. We wept together in my room, and then it was also difficult for my daughter, Juliet, who's 10. I had to try to explain some of this to them. I mean, my children, to this point in their lives, have had the benefit of growing up in a cocoon where they have not yet experienced hatred or violence. And for Vivian, to understand that there would be a risk to her brother or the son she might have one day of that kind of brutality has been an ongoing conversation. It's a difficult one for us, like it is for Americans all over the country.
Yeah, and I'm not real sure that Dick Durbin was expecting that response. Powerful, right? She's a mother of 7 children. 2 of them are black. 2 of them have been adopted from Haiti. And so their reaction to George Floyd was very personal, right? It was very sort of maybe more impactful to their family than some others. And she calls that right out. And I don't really know what the point of that question was, other than, after that response, which I thought was very powerful, very relatable. I think we can all understand what that, what their family is going through. We maybe can't understand what it feels like to be a 17-year-old girl who witnessed that. But, powerful, personal. It's detailing how she interacts with her family, and something that I think resonates with a lot of Americans. Now, what Dick Durbin is trying to do here is actually sort of connect all of this back down into a legal argument that supports racism. So he goes through, and actually I think Dick Durbin was probably the most effective here at actually getting some answers about how Amy Coney Barrett thinks, at least, in terms of her judicial philosophy. A lot of the other senators were just going about, just repeating talking points ad nauseum. What Dick Durbin was trying to do was actually, kind of needle in there and really try to figure out how she thinks and how she works. And I thought it was interesting. I don't think it was particularly effective, but it was very interesting. So he goes through, and then the next argument is that he wants to take apart this dissent that Amy Coney Barrett wrote, the one in particular that we've covered on this channel several times, where she is detailing how she would rule on the firearms rights of convicted felons. And there's the dissent in the Cantor case that we talked about, and we have a little bit of a clip of it next, where she is saying that for a government to take away somebody who's been convicted of a felony, to take away their right to possess a firearm, they have to show that that person is dangerous. And she goes into this distinction between individual liberties and civil liberties in these different contexts. But she's talking specifically about the process that needs to take place before you take away somebody's constitutional right. And she's saying that as an originalist, if you go back to the founding documents, if you go back to when the Second Amendment was written and what they intended there, that means that is a fundamental constitutional individual right. And before a court can take away a felon's ability to possess a firearm, they have to prove one additional element, and that is dangerousness. And so that's pretty clear. But Dick Durbin, what he's trying to do is distinguish that, and because her dissent sort of talks about maybe you can take away a felon's right to vote. So he's wondering, well, wait a minute. If you can't take away their right to possess a firearm, but you can take away their right to vote, why is that? And she goes into this detailed explanation about it being an individual liberty versus a civil liberty. And she's not even really coming to a conclusion on that. And she says so in the next clip, specifically she's not coming to an opinion on that issue on the voting, because that was not the issue before the court. But she is saying that this is important. So what Dick Durbin is trying to do is then weasel that around and actually use it to say that she supports taking away voting rights from felons. So her opinion was about not taking away gun rights from non-dangerous felons. He's reframing it and saying, but that means you're okay with taking away voting rights from felons. Then he takes that one step further, which is clever, and says that, okay, but you know that after the Reconstruction during the Civil War era, that a big reason that these felons, the statutes were placed to eliminate felons from voting was because all of the people during the Reconstruction era, particularly in the South, were criminalizing a lot of the things that African Americans like to do. And then when they would prosecute them for crimes, they would label them as felons, and then that would revoke their ability to vote. So he's saying essentially trying to connect the dots to say that her opinion is ultimately racist. She's, he doesn't say that, but that's what he's implying. He's saying if she is okay with allowing felons to have guns, but not okay with allowing felons to vote, that the whole basis for the removal of their ability to vote stems from the Reconstruction era, systemic racism that existed back then. And so he's trying to just sort of connect the dots in that way. Don't think he made it there, because I think that her statement and her response to the George Floyd video was so powerful that it's really hard to call her a racist after that, or to imply that she has any racist bone in her body. So she diffused that line of questioning, I think, before it even started. And Dick Durbin just kind of pushed on as you would expect. And so this next clip is about the gun rights for the felons.
I can. So we've talked about precedent, and in my court, the Seventh Circuit, there is precedent saying that phrase doesn't control. As my colleague Judge Frank Easterbrook has said a number of times, that judicial opinions aren't statutes and shouldn't be read as if they were. So Heller obviously wasn't about the scope of the right, its application to felons or those who are mentally ill, et cetera. And so that passage was dicta. It didn't fully dive down into it. But what I did was apply Heller's methodology. Both Justice Scalia's majority opinion and Justice Stevens' dissent used an originalist methodology to answer that question. And I concluded that based on that history, one couldn't take the right away simply because one was a felon, that there had to be a showing of dangerousness. And I didn't rule out the possibility that the government might be able to make that showing about Ricky Cantor. But I think we could all agree that we ought to be careful of saying that because someone's a felon, they lose any of their individual rights.
I want to get to that point.
Yeah, and that was the statement that stuck. We got to be careful before removing anybody's individual rights just because they're a felon. That was her point. That was verbatim what she just said. So I happen to agree with that, right? We talk a lot about that here. You can be charged with the crime, you can pay your debt, you can serve your time, you can complete your probation, you can do all of the things that society has asked you to do, but you're still, according to our current criminal justice system, considered a second-tier, second-class citizen. You lose you're a felon in Arizona, you lose your right to vote, you lose your right to possess a firearm, you lose your right to a lot of other federal benefits. I mean, it's difficult to find a place to live for many of these people. So that is not what we want. We want a system of justice where people are reformed, they are rehabilitated, they do not reoffend, and we do not just operate purely based on punitive measures. We want some sort of reformation process to help people get past that difficult moment in their lives and get back on track. And that's consistent with what Amy Coney Barrett's talking about. She's saying just because they're a felon doesn't mean you just start to get pulling their rights away. It's not okay. And she says that specifically based on precedent in the United States that it requires a showing of more. It requires this element of dangerousness. She wants that specifically to be found. And Dick Durbin goes on and he says, well, isn't that really complicated? And don't we have to do this individual analysis on every case and all that stuff? And the answer to that is no. I mean, every case is getting looked at anyways as it's going through. A prosecutor has to look at it. They have to file a probable cause statement. They designate crimes as dangerous crimes if they involve guns or if they involve gang activity or those things. So a lot of this stuff is already happening, and she's just explaining that away, not indicating that somebody who's mentally ill should have a gun or that somebody who's been convicted of a dangerous felony should have a gun. That's not what she's saying at all. But she is saying that more consideration should be had before we just start pulling away individual liberties that are constitutionally, enshrined in our law. We can't just pull those away from people. And I had just happened to totally agree with her on that. So we move on. We go to Senator Mike Lee. Mike Lee, a lot of people are a huge fan of him. To me, his whole statement today was just a lot of sort of pontificating, sort of the Republican version of what the Democrats are doing. He goes on about originalism and textualism. He doesn't even hardly ask her any questions. He asked her a couple very brief questions at the very beginning. He says, what do these different laws mean about originalism and textualism and all that stuff? He goes on this big rant about abortion for a very long period of time. He asks her a little bit about the size of the court and asks her to sort of expand on that. Gets real clear that the size of the court is set by Congress. Constitution is silent to the size. It's been 9 judges for over 150 years. And he just goes on this long rant about whatever he wants to talk about. Not particularly relevant. I don't like when these people go on huge rants because we're not here to, this is not about hearing them rant. This is not about their political opportunity. They say, I think Congress is Hollywood for the ugly people, right? All of the good looking people go to Hollywood. All of the other people who can't make it because they don't have the face for camera, they go over to Congress. And this is their time to shine. This is their big debut. And so they do this. And both the senators, Republicans and the Democrats, are guilty of this. And it is frustrating on both ends because that's not what we want. The American people, we want to know, what is Amy Coney Barrett going to do? Are they going to ask her difficult questions? We've already heard enough speeches from these people. We don't need to hear it again. So Mike Lee does that. And then it goes over to the Democrats. And Mr. Whitehouse does an even worse version of that. So Whitehouse is this senator here. And he doesn't even ask a single question in his 30 minutes. It's this fellow right here. He pulls out all these different cue cards. So he's got all these different cards and he's just like throwing them up on here one after another. And he's going through this, ranting about the Federalist Society and, doing all of these strange things. He talks a lot about hypocrisy. He says this whole thing is a rush. And then he's trying to connect the dots between all these different organizations talking about money. So he's talking Federalist Society, and he's trying all these arrows and diagrams, and it's kind of hysterical. He's got this Sharpie here, and he's working real hard to just kind of connect these dots, and it's pretty funny. It kind of looks like one of these scenes from It's Always Sunny in Philadelphia, if you remember this one, where this is what it reminded me of. He's trying to connect all these dots, and he's making his point. He's making his argument that the Federalist Society is responsible for funding a lot of these groups. I mean, essentially what he's talking about is lobbying. That's all he's talking about. He's saying all these different groups are lobbying each other, and they're all, funding these causes, and they're hiring lawyers to submit these briefs and petition the Supreme Court for a writ and all this stuff. And you go, okay, we all know that, right? Washington is just packed full of just disgusting money and gross people trying to influence these people. And he's calling it out in the context of the Federalist Society and this whole big scheme to, put conservative judges on the court, which, okay. I mean, it was a nice little show and tell piece. We didn't learn anything about Amy Coney Barrett because, as far as I know, she's not a member of a lot of these organizations. I don't really know what he's talking about other than he's just pontificating about money. So kind of interesting. Did not ask her a single question for his entire 30-minute period of time. So we'll just move on beyond him. Senator Ted Cruz came out. Now, Senator Cruz was back in the hearing room yesterday. He was appearing by video conference, and he actually does an interesting job. He also doesn't ask a lot of questions. So the Republicans have a different reason for not asking questions. They want to just save her energy. They want to save her from, having to be on camera and on the clock so much. And so that's their strategy. They want to keep the limelight off her a little bit because they know she's going to get grilled by the Democrats. So Ted Cruz goes through and he just kind of goes on one of his rants as he does, where he asks her why these different amendments are important. Why is freedom of speech important? She says, well, freedom of speech is important because we want to protect minority viewpoints. We don't want only the popular speech to be protected. We want all speech to be protected so we can have dissenting ideas and have a free and open society and all that stuff, right? The good standard boilerplate answers for all of those things. Nothing complicated, nothing that's going to require a legal scholar to, concoct some sort of a response. Very basic, very generic stuff, but not particularly interesting, quite frankly. Now, he does go through, and he goes through a lot of case law. And remember, this was somebody who actually has appeared in front of the Supreme Court, also a brilliant legal mind, somebody who did very well in law school. A lot of people were even talking about him going on the Supreme Court at one point or another. And so he knows this stuff very well, and he knows it probably as well as Amy Coney Barrett does. Maybe not as well because it's not his full-time job, but he's well polished on how this stuff works. So he goes through, and he's drawing this distinction between all these different cases and saying, look how close this was. He talks about Citizens United, which was the case that basically allowed corporations to now spend their money to influence political campaigns. He talks about it in the context of an organization making a movie about Hillary Clinton when she was running for office. And during the oral arguments in front of the Supreme Court, Justice Alito asked one of the individuals who was representing the government from the Obama Department of Justice and said, hey, if the government wanted to ban books, could you ban books? That person said, yeah, we could. And so he's saying, oh my goodness, we're living in a country where that is almost going to happen. He said, that was a 5-4 decision. It could have gone the other way, and we could be looking at case law set by the Supreme Court, which says that the government can ban books. Wouldn't that be scary? And he does that. He goes through Heller, which is the gun rights case. He goes through the Religious Restoration Act. And, he's pretty effective when he goes on these little tirades. He kind of draws these things one next to the other and establishes a good theme that, right now they're talking about this idea that the Supreme Court is really slanted to the right and it's going to be just a conservative massacre. But he's saying, no, it's not so close. We were really close. We were 5-4 decisions on a lot of these things, and it could have gone the other way. And these are liberties and freedoms that Americans truly cherish. So I thought it was effective. Again, we didn't learn anything about Amy Coney Barrett, almost nothing. That's not true. We learned a little bit about her personal story. He does go into that. He asks her, do you speak any other language? She says, I speak a little French. Do you play, any instruments? Yes, she plays the piano. Her kids play the piano. Asks her specifically about the distance learning issue in light of the COVID lockdowns. How are all of her 7 children doing with that? She says that it was difficult, as it is for most American families. Talks about the adoption process and how that all laid out. And it's a pretty beautiful thing. They got married, they had the first child, went and adopted another, young gal, and then had more children and adopted another one. So, very powerful, very, I think, moving, and it was able to draw out a little bit of the personal story, which was effective in these things. We get to Amy Klobuchar. So Amy Klobuchar, if you recall, she was running for the presidency, and she actually made it fairly far in the Democratic primaries. And she kind of comes out swinging in this thing. And she says that at the very beginning, she wants to reset everything. She wants to reset the context here. And she says, look, this whole hearing is a sham. And that's the language that she uses. She says, this is a sham hearing. And we are in the middle of a coronavirus pandemic. We're in the middle of an election. blah, 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 right? Everything, this whole thing is a sham. It should not even be happening. The last time we did this was with Abraham Lincoln, and then she just starts queuing up her cue cards. So a lot of the Democrats had these cue cards. They had these pictures of other people, and they had these diagrams, and so she pulls up hers. And of course, it's a picture from Donald Trump from one of his tweets. And he asks Amy Coney Barrett about that, and she says, look, I can't comment on the president's tweets. Nobody promised anything from the executive branch, and that's all there is to it. They spend a lot of time, Amy Klobuchar and Amy Coney Barrett, talking specifically about this issue of what's called a super precedent. And Amy Coney Barrett gets a little bit, this is the first time we see her sort of nudge back a little bit. This is sort of in the afternoon of the day. They've already gone to lunch. She's already answered this question about 100 times today. And so she gets a little bit testy. This is the first time we see it. And we may see more of it tomorrow, but let's take a look at what she has to say. So it's this idea of what's called a super precedent. Precedent that the Supreme Court has decided that is so grounded, it's so ingrained in our law, in our way of thinking, that it's just unfathomable that we would ever overturn it. There's no lawyer, judge, politician anywhere who in their right mind would overturn that case. She's talking specifically about Brown and the segregation case, talking specifically about Marbury versus Madison, which is the case that establishes judicial review for all of American law. So these things are so fundamental, they can't be changed. But Amy wants her to make that same statement about Roe versus Wade, and that one doesn't fall in that category. It's not super precedent. And so what Amy's trying to do is to get her to distinguish that. Well, why not? She does that, but then Amy Klobuchar doesn't like her answer. Let's take a listen.
With a view that when a justice's best understanding of the Constitution conflicts with Supreme Court precedent or case law, it is, quote, more legitimate for her to follow her preferred view rather than apply the precedent. And I want to run through a few examples. So Brown v. Board of Education, as we know, that holds that the 14th Amendment prohibits states from segregating schools on the basis of race. So is that precedent?
Yes.
That can't be overruled.
Well, that is precedent. And as I think I said in that same article, it's super precedent. People consider it to be on that very small list of things that are so widely established and agreed upon by everyone. Calls for its overruling simply don't exist.
Okay. Well, you also separately acknowledged that in Planned Parenthood v. Casey, the Supreme Court's controlling opinion talked about the reliance interest on Roe v. Wade, which it treated in that case as super precedent. Is Roe a super precedent?
How would you define super precedent?
I might have thought someday I'd be sitting in that chair. I'm not. I'm up here, so I'm asking you.
Okay, well, people use super precedent differently.
Okay.
The way that it's used in the scholarship and the way that I was using it in the article that you're reading from was to define cases that are so well settled that no political actors and no people seriously push for their overruling. And I'm answering a lot of questions about Roe, which I think indicates that Roe doesn't fall in that category. And scholars across the spectrum say that doesn't mean that Roe should be overruled. But descriptively, it does mean that it's not a case that everyone has accepted and doesn't call for its overruling.
Okay, so here's what's interesting to me. You said that Brown is, and I know my time is running out, is a super precedent. That's something the Supreme Court has not even said, but you have said that. So if you say that, why won't you say that about Roe v. Wade, a case that the court's controlling opinion in that Planned Parenthood v. Casey case has described as a super precedent? That's what I'm trying to figure out.
Well, Senator, I can just give you the same answer that I just did. I'm using a term in that article that is from the scholarly literature. It's actually one that was developed by scholars who are certainly not conservative scholars who take a more progressive approach to the Constitution. And again, as Richard Fallon from Harvard said, Roe is not a super precedent because calls for its overruling have never ceased, but that doesn't mean that Roe should be overruled. It just means that it doesn't fall on the small handful of cases like Marbury versus Madison and Brown versus the board that no one questions anymore.
Is United States v. Virginia military, is that super precedent?
Senator Klobuchar, if you continue to ask questions about super precedents that aren't on the list of the super precedents that I discussed in the article that are well acknowledged in the constitutional law literature, every time you ask a question, I will have to say that I can't grade it.
Okay. Well, I am then left looking at the tracks of your record and where it leads the American people. And I think it leads us to a place that's going to have severe...
Yeah. So she's upset about that. So Amy Coney Barrett just kind of, smacks that one right out of the park, right? You can keep asking me about all these cases you want. If they're not on the list, they're not super precedent. And what all Amy Klobuchar is trying to do at this point is to just really make her say that Roe versus Wade is not super precedent, which she did. She said it's not. But she's very clever about how she did that. She said, listen, if it was super precedent, why are you people asking me so many questions about it? Why are you so petrified that this case is going to be overturned? It's because from legal scholars all over the country that Roe versus Wade, although you may like the outcome, it's not well-reasoned, good Supreme Court law. And the Supreme Court itself has said so, which is why they modified it with Casey versus Planned Parenthood. So she's saying, listen, by your own questions, it's pretty clear that this is not super precedent. It's pretty clear that a lot of people want this thing overturned. A lot of scholars think they want it overturned. A lot of people on both sides of the aisle said this is not a good case. And so the fact that you're asking me about it, you and all of the other senators here show by itself that it's not super precedent. So a little bit, testy there. And I like that a little bit. I like to see her push back on these questions because it does become sort of a repeat broken record. And we're going to hear more about it tomorrow without any doubt. So then we move over to Senator Hirono from the great state of Hawaii. So Senator Hirono is out and she starts off with a lot more pictures. She goes through more pictures. We have this one here where she's showing somebody who died from coronavirus, right? So over here, we see this person is holding up a picture of their lost loved one. May they rest in peace. But a lot more of this, right? A lot of the persuasion, a lot of the personal stories. This is going on into the afternoon. We talked about this yesterday. The Democrats are very good at establishing a theme and sticking to the theme, and they did so all day today. She is, for some interesting reason, to me, she seems sort of the most... I would say sort of off in her questions or sort of off on the theme because she starts off her line of questioning with asking Amy Coney Barrett if she's ever essentially raped anybody before.
To ensure the fitness of nominees for a lifetime appointment to the federal bench or to any of the other positions for any of the committees on which they appear, I ask each nominee these two questions, and I will ask them of you. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator Hirono.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
Judge Barrett, do you think it is appropriate for justices to consider real-world impacts in their decision-making as justice?
All right, so then they go off into a different question. Just a weird line of questioning. So you know the way this works, right? They submit questionnaire after questionnaire after questionnaire. This person is Amy Coney Barrett has already been confirmed to the 7th Circuit. She's already been vetted. She's already had a background check, already been cleared by the FBI, all of this stuff. All of this it's just political posturing. And I don't even know why that question would come up. I mean, there's been no indication of that at all. I don't think there's any victims. It's just like her doing her due diligence, but the due diligence has already been done. We already know the answer to that question. The FBI knows the answer to that question. Do you think Amy Klobuchar is going to say, yeah, you know what? I've been working for this position for the last, my entire life. And all of a sudden, you're right, I forgot about that one situation in high school. Like, that's not going to happen. This is just insulting in my mind. It's just not even... It's unprofessional. It's not dignified. It's an embarrassing question. It's totally inappropriate, but she asked about it and she's entitled to do that. We move on. We go over to Senator Cory Booker, who is, he's actually a pretty reasonable, pretty fair sort of interviewer here. He's asking her questions and he's saying, hey, I'm sorry, I don't want to talk over you. Please, finish your question. And he's sort of affable as he's going through his line of questioning. Now, to me, it seems phony as hell, but he's at least on the face of it, pretty affable, pretty easygoing. He talks specifically about the transition of power. So he's really ripping on Donald Trump as he's going through this thing, saying that a lot of other people would agree to a peaceful transition of power. Donald Trump hasn't done that. He asks her specifically about, can the president pardon himself, which is a good question. Also, the president is in debt. What is that going to do to potential room for having him having a conflict of interest in the executive, having a conflict of interest in the White House. And so he asks her those questions and she just punts them away as she does. She says, look, these are active cases. These are active controversies. There may be a time and place where these issues appear in front of the Supreme Court and I can't answer that. And they all know that. The senators know that. They've heard the line before. They know that these judges are bound by certain canons of judicial conduct that they can't answer a lot of these questions, but they ask him anyways because, again, it is a political hearing. It's not really intended to answer these specific legal questions because they can only be answered after they go through the process, after they go through the judicial process, and after they're heard in court. We wrap up the day with Senator Mike Crapo, Crapo from Idaho, and he asked her specifically about recusal. Now, I sped this one up a lot. I think I did this at double speed because we've already heard the answer to it, but I want to just show you how polished Amy Coney Barrett is. I mean, she just rifles right through this. He says, okay, look, I know you've already answered the recusal question like 5 times today. Can you just give it to us one more time? And she does. And she's very masterful at articulating the different points of analysis that she would go through in the case of recusal. Because what the Democratic Party wants to hear her say is that, yes, if there's any election issues that come up in front of the Supreme Court after November, are you going to recuse yourself from those cases? And she's saying, I can't do that right now. There's a process that we have to go through in order for a judge to recuse ourselves. And it's very detailed. And she explains what that is right now.
Next, I want to go to one more specific kind of process type thing to make sure we all understand, right? And that's the recusal. Interestingly, you've been asked by my colleagues on the other side to assure that you have made no commitments about case law, but that to give a commitment on recusal. You have said that there is a process for recusal as well, and that you would follow that. But could you please lay that out again, once again, for us?
Yes, recusal is a question of law because 28 U.S.C. 455, the recusal statute, actually obligates a judge to recuse in certain cases of either actual bias or apparent bias. And there are Supreme Court precedents interpreting the range of a judge's obligations under that statute. There are also, professional conduct committees to consult, and I think collaboration and consultation, as I said before, with other justices is a typical practice according to Justice Ginsburg's description of it. So it is a legal question that's governed by statute and precedent, so it's not one that I can make an advanced resolution of.
All right, thank you.
Yeah, so again, very, very good. This is somebody who is just answering the questions as they come in, and she just goes right through the law. Boom, 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 boom. This is how I would approach it. And so I sped that up double time because it's, we already know what her response is on that, but very polished. All right, let's go over to the chat. I have a little bit of time for a couple questions. Let's dive into it because today is Tuesdays, and Tuesdays are short days, unfortunately. All right, so let's take a quick look and see what is going on here. See if there's any questions in the chat. Days are short days, unfortunately. All right, so we have Hirono is high from Scott IXS. We have Senator Hirono can't be accused of sexual bias that way. She asks salacious questions of everyone. Expect this junk from her every time. Can Congress always be 2x speed? Yeah, I mean, I listened to most of the hearing at 2x speed because it was just so mind-numbing. It's funny. If you listen to 2x speed and then you turn it down to 1x speed, these people look not too good. You really realize how slow they're talking and how much time they want to just capture everything and expound on all of these issues. You're like, yo, get to the point. Enough already. So Gigi says, so you like Amy? I am liking what I'm seeing from her. Yeah, I'm really liking what I'm seeing. She's very on point. She's just going back to the originalism every time. I think she's very personal. She's got a good story, highly polished. I don't think I've seen her rattled at all. From what I have seen thus far, I do like Amy Coney Barrett quite a bit. Now, I am perfectly ready to be extremely disappointed by her. Okay, this is what happens. We put these judges on the Supreme Court who say that they're going to be textualists and originalists, and then a couple of years fly by, and we end up with Judge Roberts, who sort of invents arguments. In particular, I'm talking about the Affordable Care Act. He just created this idea that it was a tax. I don't know where that came from, but that's what he used as justification. And I thought the same thing about him as I do about Amy Coney Barrett. I thought they were both originalists, and we saw what happened with him. So I'm liking what I'm seeing from Amy Coney Barrett. She's answering all of the right questions, but for some reason on the Supreme Court, once these people hit the bench, they make this immediate leftward lurch, and it can be very frustrating. Yeah, Tuamos Holo says Robert Barnes hates her. He created a whole... Robert Barnes is not a fan of Amy Coney Barrett. I understand that. I really respect Robert Barnes. I respect his opinion. I think he's, very, very interesting. And I think he's got good legal analysis, but I think we're just a little bit off on that one. She had a face of stone, poker level 100. That comes from Fermenti Mountain. USA Libertarian says, yeah, she's actually answering the questions. President Trump said that Kavanaugh should sue Blasey Ford. Is that possible or probable? I think he could sue her, but it would be, what's the point of that? She failed to derail his confirmation hearing. He's on the Supreme Court now. That's over. I think if he did sue her, it would be just beneath him and the position of the court. That is done and over. There's no need to revisit that chapter. The worst case I remember was the one about growing pot for your own use, and the Supreme Court ruled that was still interstate commerce. Yeah, there's a lot of that. Those Commerce Clause cases are ridiculous. Some of the most infuriating cases that I ever read, I think, in law school. There was one case, the name escapes me right now, but it was this idea that even growing, it wasn't just pot. It was growing just even food for yourself because of the fact that it could be put into interstate commerce. It was part of interstate commerce. Just hypothetically speaking, it could go out. You didn't even need to have to be selling it. You just had to put it out there. And so that was a very frustrating series of cases, the Commerce Clause cases, which are very frustrating. Robert Barnes is a Renaissance lawyer. His depth of law is astounding. I disagree with him on ACB. Lagoa will get her chance. Yeah, Robert Barnes is brilliant. I mean, he can speak about a lot of different things, which is very impressive. If you could remove or add any law, which one would it be? Well, from a criminal justice perspective, one of the first things that I would reform is qualified immunity. The idea that if you're acting on behalf of the government, that you get this higher echelon of immunity. You're more protected than other people because you work for the government. As long as you can make some sort of rational argument that you were acting under the agency and on behalf of the government, you have to do something that is grossly negligent in order to be held culpable or liable for that activity. And it's a much higher standard, and the courts have found that it's really expansive. I mean, these people are really, really protected. And what that means is they don't get held to the same level of accountability that you or I would. They get slaps on the wrist, cases don't even get charged, and it's all just considered qualified immunity. So I would love to see that one gone, qualified immunity gone. I would also really like to see something done about the police unions. I don't know specifically what type of law that would look like, but I think the police unions have way too much power. They have way too much ability to negotiate the contracts in a way that keeps bad officers, bad cops on the force, protects them, keeps their records clean, and keeps them around. And I think a lot of the problems that we're seeing on the streets, the types of officers like we saw with George Floyd, with Rayshard Brooks, with, Breonna Taylor, all of them, I think are being protected by the police union. So I would like to see both of them gone. I'm so tired of senators just flat out lying in these hearings. If they were honest, they could just say what they want, a legislator on the Supreme Court, not an originalist. Yeah, that's exactly right. That's exactly right. That's what they want. They want somebody on there who's just going to rubber stamp the legislation that they pass. And that gives them a lot of license to pass terrible legislation because now the people just rubber stamp it. So they don't need it. They can just say, well, they can have this conversation between the two parties, between the court and between the Senate or between the Congress. And that's not what we want. We want a separation of powers. The court is not supposed to rubber stamp anything. It's supposed to weigh it and measure it and boot out the stuff that is unconstitutional. And if the beautiful thing is if Congress doesn't like that, then they can just pass new laws. They can amend the Constitution. There's a lot of mechanisms that our country has to modify the laws that the people don't like, but that should not take place in the judiciary. Shouldn't be a part of the court. How do you feel about senators these days voting straight party line? When she clerked for Scalia, forgot his name, and he was confirmed 93-0, she judges like him, she says. She judges like him, she says. So Amy Coney Barrett, during her confirmation hearing today, had made it a point a number of different times, and that question came from Eric Highsmith, that she said a number of times that I am not Justice Scalia. I am Justice Barrett. And although he was a mentor of mine, I'm not going to be sort of a carbon copy of Judge Scalia. She says, I've got my own views. And actually it came up during the hearing that there were times when she disagreed with him. And I think that's fair. So I do think she's highly qualified. I do think that there's no real legitimate reason why she's not qualified for the Supreme Court, right? Previously, they wanted to say with Kavanaugh that it was these rape accusations and those things. I don't see any legitimate reason for it. I think she's qualified to be there. And if these senators were voting according to qualification, then she would be appointed, 98-0 or 100-0, really. But that's not what they're doing. And they're all looking for cover. So keep this in mind. The Democrats, their line of questioning, they need to come up with something that they can take back to their constituents back home as a justification for why they didn't vote for her. And what that is looking like, they're settling into a couple different buckets. One is the Affordable Care Act, Obamacare. They're saying that if I vote for her, it's going to take the health care away from my constituents. So that's going to be their cover. She hasn't been clear on ACA, therefore can't vote for her. The other one is because this whole thing is just a sham, according to them. We're already underway in an election, and even though she is highly qualified, we're not going to vote for her because it's already an election season. So those are really the two main buckets that I have seen, and I think they're going to stick to that all throughout tomorrow and probably Thursday as well. So black letter law seems to be fairly similar to the concept of super precedent to the layman. This comes from Ma the Fox. Could you explain what the difference is? Yeah, so black letter law is really where you're looking at what that's referencing is this idea that you're looking at the exact statute. You're looking at the law, the specifics of the law. The other question that you're referencing is, wait, your message just went away. Okay, so super precedent. So black letter law would be like you look up a statute, right? You say, what is the specific law on that? You go to the statute, like murder, you go specifically ARS, Arizona Revised Statutes, whatever it is, that's the law. We're looking at the law, the actual written text of the law. Super precedent is this idea that it's evolving cases that are being sort of stacked on top of one another, and it's case law versus statutory law. So in case law, we're talking about this super precedent, meaning that the judges have agreed on it. We've put that in a legal opinion that has been trickled down throughout the rest of the country, and then it's been integrated into our system of justice because other cases are relying on that precedent. So think of it sort of as like the foundation of a house, or it's like the first brick when you're building a wall. Once that is established, all of the other bricks are going on top of that. And so you can't just pull out that bottom level of bricks. That's kind of what we're talking about super precedent. These cases are so fundamental, so many other things rely on them that they are ingrained into our system of governance, and they're not going to change. It's a little bit different than black letter law, because black letter law, you could just go ahead and change. So you could just say, I don't like that statute. We're going to change that. We're going to modify that. It's a little bit of a little different. I don't even know if I would put them in the same analytical bucket, but a good question. And we got a super chat. Oh my goodness. We just turned this on. Faith turned this on. So we got $5 from USA Libertarian. Local prosecutors investigating police brutality is a conflict of interest. Yeah, and that's exactly right. This is something where I have a big issue with this, because I don't think that it makes sense to have people investigating themselves and then finding that they didn't do anything wrong, right? And so what these different agencies will often do is if a police officer gets into trouble, they'll bring in a neighboring police agency. So you have one county who will say, yeah, it's happened in our county. We can't investigate it, but we're just going to send it to our neighboring county. And so we've seen that in a couple different situations. We're seeing that right now with the George Floyd case, right? The 4 police officers who were involved in that case, they brought in, I think, the actual state investigators, not the local county investigators. And so they're bringing in outside agencies to go and assist them in the investigation, because they want to sort of promulgate this idea that there's a separation there. There's no conflict of interest because it's separate. They're bringing in an outside independent third-party agency to come in and do the investigation. They're not doing it themselves. But I still, even with that, just think about this, right? A lot of these are different organizations that are all sort of tied and connected together in different ways. And so that blue shield, that blue coat of silence is still permeating, I think, throughout the entire law enforcement culture, just in general. Thomas Holo, another super chat. Oh my goodness. So this is fun. So he says, I appreciate your analysis. I don't always agree, but I appreciate your comments. Yeah. And that's all we're trying to do here. I mean, I know that a lot of my comments, a lot of my opinions are not going to be, viewed upon favorably from everybody, but I'm just trying to give you my perspective as somebody who's a criminal defense attorney, somebody who believes in liberty, somebody who believes in freedom, less government, and really justice across the board, not for just the clients, the people that we represent, but also for the other people who are in charge of the system, right? Why should we be held to one system of governance, to one set of statutes and laws, but the people, the politicians, the police officers, the prosecutors, the judges? I just saw an article today, a headline literally, that a Supreme Court judge from, I think it, what state was it? A Supreme Court judge was pushing an officer, threatening him and all of these things, and he didn't get arrested or charged with that. You or I would be thrown in jail with aggravated assault on an officer, and our lives would be dramatically different, if not ruined. But because he's a Supreme Court judge, he gets a different set of justice. Very, very frustrating. And we want to make sure that that is done away with. And I think the only way to do that is by having people hold their elected officials accountable. And that's what we want to do on this show. It's why we call it Watching the Watchers. Zulu Zite says, good call on the super chat, Faith. You're awesome. So Faith turned that on, and pretty cool. You know, I've never seen how this works, and I'm learning on the fly as this goes. So we really appreciate that. Thank you, everybody. Attorney Robert Barnes says Barrett is a Trojan horse. Yeah, many people can see that. Somebody else. So I think Gigi said that I stopped receiving notifications at the stream at 6 on your channel. Did you change any setting in your channel? So yeah, we're still trying to figure this out. So what we're going to be doing now is actually scheduling the streams. And we didn't do that these last few days because I wasn't real sure what I was going to be talking about. I knew it was going to be about the confirmation hearing, but we didn't schedule them in advance. So we will do that so you get those notifications. And then I am going to be making separate videos. So I'm going to make a video this evening, if not first thing tomorrow, about the Doloff case. So I did a deep dive on that last night. I've got like 35 slides analyzing all the different angles and the case law, the murder statutes from Colorado. Don't think it's looking particularly good for Doloff, but we'll have an analysis on that as well. MLP Death Dealer says that they subbed during the Rittenhouse coverage. Yeah, and we're going to get back to Rittenhouse. Rittenhouse had his extradition hearing last week. A lot of the cases that we normally cover are just a little bit on hold because of what's going on the Supreme Court. And I know that is not what a lot of you want, right? A lot of you are subbed for the criminal law, the criminal justice stuff, and I get that. Even right now we're at about like half of our normal viewers because a lot of people just aren't particularly interested in the Supreme Court stuff. And I understand that, but it is so critically important. I mean, this is reshaping the court. This is something we're going to be living with for the next 50 years, truly. And so we want to make sure that we are covering this. I know it's not the most exciting stuff. People get tired of hearing senators. It's like brain damage. I was listening to this today and I was just like, oh my gosh, can we just do a vote on this thing? Because we know she's qualified. We know that all day tomorrow they're going to be asking her the same questions again, and we're going to have to listen to it. But it is that important and it's worth it. We're going to be here. This is history in the making and we want to be a part of it. So I appreciate the patience on that. We will get back to our original programming. Ma the Fox says, and I follow politics very closely, and I know that law and politics are intertwined more than I'd like to think. Yeah, they're very closely intertwined. Very, very closely intertwined. Looks bad for Doloff. Hell of a shooter, though. He got good training. Republicans should wake up to the danger that these people now have. The same arms now. Supreme Court situation is fascinating, and it's happening right now, not later. Yeah, and that's from Zulu, and that's why we're going to cover it. So I know it's not as, kind of as flashy or as sexy as some of the other cases, but it is important, and we want to make sure that we're a part of it. How about the Rosenbaum mental health issue? He was just released from a suicide attempt, and he looked like he was still trying, maybe to get Kyle to assist. He did ask to be shot. I like listening to Barrett's explanations, though. It's very educational. Yeah, she's great. She did a very good job. Very, very good job today. All right, everybody. Well, listen, I want to thank you so much for being here. We are going to wrap it up here because I got to get moving, but we'll be back here tomorrow. It's going to be more Supreme Court stuff. I am going to work on a couple of other projects and try to get some videos out on those as well. So be on the lookout for those. I'm going to try to get those done tonight, maybe first thing tomorrow on the Doloff, because it is an interesting case and we want to run through that. I really appreciate you being here. Joining me as we trek through this Supreme Court confirmation hearing, where I think we're almost done with it, and it's going to to be very interesting. We may have a new Supreme Court judge and a 6-3 court for the foreseeable future. What's that going to do to the election? What's that going to do if Joe Biden wins? Are they going to pack the court? We got a lot of open questions, a lot of issues coming forward. And I'm so grateful that you're here because it's a lot of fun not talking to myself on these things. I appreciate talking to you guys. So thank you so much for being here. We'll be back here tomorrow at the same time, same place, 4 p.m. And we will schedule that so you do get the notifications. Have a wonderful evening.